Beloved viewers and subscribers, in this video we will be seeing about judicial opinion or what Kerala High Court said to a person who requested to quash the FIR and to quash the criminal proceedings when he was accused of attempt to murder and voluntarily causing grievous hurt using dangerous weapons or means. So, what was the court's opinion? That is what we are going to see here. So, the judgment was delivered by the Kerala High Court on 27th January 2023. So, the judgment was delivered on 27th January 2023. So, there was one person came with two requests or two petitions. So, the petitions were applied or sought, orders were sought from the High Court under section 482 CRPC. I have given what is section 482 CRPC here. See, it talks about the inherent powers of High Court to make orders as may be necessary to give effect to any order under this code, to give effect to any order under this code, to prevent abuse of process of any court, or to secure the ends of justice. Now, as I mentioned already, the person was accused of section 324 IPC, which talks about voluntarily causing grievous hurt using dangerous weapons. Then section 307 IPC deals with attempt to murder. Then the person was also accused under these sections of the prevention of atrocities of the schedule against the Scheduled Caste and the Scheduled Tribe Act of 2015. The original principal law was that of 1989. Now, the petitioner requested to the High Court on two grounds. See, what actually happened was reportedly, here the petitioner is actually the accused. The accused or the person alleged on the day before committing the actual crime of attempt to murder and voluntarily causing grievous hurt, he restrained the victim. He came down from his car and he threatened the victim and he left. That is the car that he is mentioning here. So after the FIR was filed, after the occurrence of the crime, the car was seized. So this accused, he went to the special court under the POA Act and sought release of the car. They didn't pass such an order. So they in fact passed an order not to release the car. So he is coming with a request to quash that order which prohibited releasing the particular car involved in the crime. Then second thing is, he wanted to quash the FIR where these sections are mentioned and to cancel all the further proceedings initiated by the respondent from the victim's side. Now, what is his counsel saying, or his advocate? What is his statements? The advocate of the accused states that we are requesting you to quash the FIR and all the criminal proceedings thereby followed by the FIR because the accused and the victim, they have settled the issues between them. And the victim also has informed through an affidavit that the particular victim has no objection if FIR and all proceedings are quashed by the court of law. Now, for this, from the victim side, the prosecutor's opinion is that the proceedings could not be quashed because 307 IPC is an attempt to murder. It is a serious offense, and offenses under prevention of atrocities against the scheduled caste and scheduled tribes, that particular law was also involved in this crime. Now, after seeing all these things, let's see what the Kerala High Court observed. Now, actually, this petitioner, he mentioned this particular case law of the Supreme Court that consider all these parameters and give us the requests such as release the car, quash the FIR, quash all the proceedings, etc. Now, the Kerala High Court also has quoted the same case law of the Supreme Court, and it gave its opinion, about which we will see in the last part of this video. Now, first it said under section 482 of CRPC, to quash the criminal proceedings for non-compoundable offences under section 320 of CRPC, it can be exercised. Quashing can be done for non-compoundable offences also, but only for those offences that are overwhelmingly and predominantly of civil character, between 2-3 persons, or commercial transactions, or arising out of matrimonial relationship or family disputes, and when the parties have resolved the entire dispute among themselves. Now, before entering into next paragraph, I will tell you what do we mean by compoundable offences and non-compoundable offences. Now, if you want to know what is compoundable offences, you have to read section 320 of Code of Criminal Procedure. Now, you might be someone who is not very aware of law, etc. Let me tell you, go to Google, type CRPC PDF, you will get a document. Government website means it will end with gov.in, .gov.in or .nic.in. Go there, open it in a new tab. In the Control F or search in page or find in page, you give as 320. Go to section 320, it talks about compounding of offences. That means certain offences are compoundable. Certain offences can be mutually settled, amicably settled between the parties. That is the meaning. And section 320 clearly gives two types of compoundable offences. If you take IPC, there are 511 sections, more than 400 offences are mentioned there, or 350 offences are mentioned there. But section 320 lists only 50 offences, around 50 offences. Some of them it says they are compoundable with the information to the court of law. You settle, then inform the court of law. That is one type of offences. Okay. Then there are other group of compoundable offences which are compoundable only with the permission of court. For example, simple hurt is compoundable with the information to the court, whereas grievous hurt is compoundable again with the permission of the court. So these are compoundable offences. All the offences other than these we can say non-compoundable offences. Now, can High Court quash criminal proceedings or FIR related to non-compoundable offences? Yes. When and how? What are the directions for it? Are the directions given in the state of Madhya Pradesh versus Lakshmi Narayanan and others. So now you would understand the first paragraph. Now the second paragraph, if High Court want to quash the proceedings, such power cannot be exercised wherever heinous and serious offences are involved. Example, murder, rape, dacoity, and etc. So the ambit widens. What are heinous and serious offences? And condition is that why for these offences High Court cannot quash? Because these offences are not private in nature. They have serious impact on society. We will consider them as crime against society. So that is why they are saying for heinous and serious offences, such quashing of criminal proceedings is not allowed. Now again, now you remember the original case what we are discussing, section 324 IPC, voluntarily causing grievous hurt using dangerous weapons, then attempt to murder. I'll come to that. Now third point, High Courts cannot quash if the offences comes under special statutes like Prevention of Corruption Act, like that. So if a public servant is alleged, or if the offence under Prevention of Corruption Act is there, High Court cannot quash. Then this state of Madhya Pradesh versus Lakshmi Narayanan says very clearly that section 307, which talks about attempt to murder, then Arms Act, they would fall under the category of heinous and serious offences. So they will be considered as crime against society. It is considered as a serious level. They are not private in nature. These are not civil. They don't have civil character. They are crime against society. Again, the state of Madhya Pradesh and Lakshmi Narayanan is very clear. Even though we say all these things about section 307 IPC that it comes under serious and heinous offences, we would give the discretion to the High Court. That is why it says it would be open to the High Court. First, High Court should examine see the FIR and subsequent documents, whether they have simply brought in section 307 IPC for the sake of it, or whether there is enough evidence, whether the prosecution has enough evidence. See the word prosecution, they are not saying investigating authorities, they are saying prosecution. We'll come why I am specifically talking about prosecution. So whether the High Court has to see whether they have simply put section 307 or they have sufficient evidence. If proved, if such evidences were proved, that will lead to conviction of the accused, or would lead to framing the charge under section 307 IPC. Say for example, now before discussing these three, I would like to bring your attention to this fourth point. Such an exercise by the High Court would be permissible only after the evidence is collected, after investigation, and the charge sheet is filed, or during the trial. That means only after police investigation is complete, only after the submission of charge sheet, a High Court can examine whether to quash proceedings that involve the offense of attempt to murder. Now coming to our case, in our case, the matter is pending police investigation. That means police have not yet submitted the charge sheet. So High Court now in our case cannot even enter into examination of whether 307 IPC can be involved or not. Whether 307 IPC, even if involved, can be quashed or not. So High Court has no jurisdiction now, because only if police investigation is complete, only if the matter is during the trial, during the prosecution in the court of law, can they examine such a request. Now let us consider there is a similar case for which police investigation is complete. It also involves section 307 IPC. Now what High Court should see? Now they should see whether it is just for the sake of it, or do they have enough evidence. Even if they have enough evidence, the court should look into nature of injury sustained by the victim. Nature of injury sustained by the victim. Whether the injury is inflicted on vital or delicate parts of the body like chest, etc. What is the nature of weapons used? These things they have to see. And then they can come to a conclusion that no, we cannot quash, or if it is for the sake of it, they can quash. That is the understanding. Okay. Now, so I hope you understood all these parameters. Finally, what they are saying, say for example, there are certain offenses which are non-compoundable offenses but private in nature, and they do not have a serious impact on society. Okay. In that case also, High Court can quash on the ground that there is a settlement or compromise between the victim and offender. In that case, High Court has to see the antecedents of the accused, history of the accused, whether the accused was earlier involved in any other offenses or any other FIR or any other criminal activity. Then they have to see the conduct of accused, whether he was earlier absconding, why he was absconding, whether the person cooperated to the police officer or the investigating authority, and then how the accused managed with the complainant to enter into a compromise. Say for example, the accused is a wealthy person. He forces the victim to come to compromise. Then such case we cannot encourage quashing, right? Say the accused expressed honest remorse to the victim and settled the matter with the victim. That is a different scenario which court can consider for quashing. There is a true remorse, restitution. There is some kind of responsibility that the offender has obliged to the victim. These are all different cases. So that is why they have included this last line, how the offender managed with the complainant to enter into a compromise. So these are all the broad themes upon which, on certain non-compoundable offenses, the High Court can think or examine about quashing. Okay, so we saw about general theme when section 307 IPC is involved, attempt to murder, then non-compoundable offenses not having serious impact, private in nature, how those cases can be quashed, for those proceedings can be quashed. Now itself you got a broad theme what High Court would have ordered in the discussed case of law, discussed case, the case that we are now discussing. So the High Court said Section 307 IPC is involved in this case. So, as the Supreme Court said in State of Madhya Pradesh versus Lakshminarayan and others, it comes under the category of heinous and serious offences. So, it is not private in nature, rather it is a crime against society. More so, your case is still in police investigation stage, so we cannot enter into examination whether this case is fit for quashing or not. More so, and even see in this case what happened. First, police filed FIR under 324 IPC, voluntarily causing grievous hurt using dangerous weapons. After some hours, they included Section 307 IPC. So the petitioner said, if at all they have to include the Section 307, they should have done it in the beginning. So this is not proper, like that they argued. For that, High Court said, see, I have to go through the medical records of the case diary or sufficient documents. When I went through that, when the High Court went through that, we could see that the person suffered serious injuries and also in delicate parts like chest, injury using knife. So that validates why Section 307 is very relevant to this particular offense, or why that Section 307 was part of the FIR. So, and the medical record clearly says the physical condition of the complainant during the stage of admission at the hospital was very serious. So 307 is validated. So 307 stays, matter is in investigation, we cannot quash. More so, the particular applicant or the petitioner, in this case the accused's anticipatory bail was also dismissed by Prevention of Atrocities Special Court and also the Kerala High Court. Keeping all these things in mind, we are dismissing your criminal miscellaneous petition which sought quashing of FIR and quashing of proceedings. So they dismissed that and they did not allow quashing of FIR and quashing of proceedings. Now, therefore, what the High Court said, the High Court directed the petitioner or the accused to surrender before the investigating officer to facilitate proper investigation of the crime, because it is crime against society as it is considered. State of Madhya Pradesh versus Lakshminarayan and others, they has to surrender within 3 days from the date of passing the order. Probably within 30th January the person should have surrendered, failing which the court said investigating officer shall arrest the accused and go with the investigation of the case without fail. Now, regarding the car, the High Court said, let me send the matter back to the special court to consider the same thing fresh. After this guy, this accused surrenders to the police, consider this matter fresh within 10 days of surrender and deal according to let the matter be dealt by the special court. The special court wants to release the car, let it release, or it doesn't want to release, let it not release. That is what the Kerala High Court said. So in this discussion in this video, we saw about Section 482 of CRPC, what are the Supreme Court's guidelines on quashing the FIR and proceedings when a non-compoundable offense is requested to be quashed before the High Court. So what are the reasons, what are the guidelines when High Court can quash, when it cannot quash? What about Section 307 IPC, Arms Act? So we discussed all these things. All these things we discussed. What are the things the court would see if it is non-compoundable offense, not serious in nature, but also relatively private in nature? What things should be undertaken, seen very carefully, and we also saw the judgment. So I think this is one of a different kind of video on YouTube. Give me your feedback on this content. If you have any doubts, feel free to ask. I'll try to give the best clearance, best explanation possible. Thank you all. Thank you so much. We'll see in one another video.